and welcome. Ari Rosenbaum here with the 100th episode of that 4K podcast. Not going to do anything special. You always do a 100th anniversary, uh, post the greatest hits and all that. First of all, I don't think this podcast has had any greatest hits. And second of all, with this Audacity software, I kind of like to just record, post, and that's it. Nothing fancy. I didn't go to 4 years of college and then 4 years in law school to become an audio engineer. So I'm not going to bother with that. But anyway, this episode is going to be about key concept you should be aware as a 401k plan sponsor. Maybe a best of. We'll talk about all the points that I always mention that plan sponsors really need to take care of and that they're probably not aware of. And of course, first things first, next week, two events, that 401k virtual bunch, which of course, I don't know if people know, but it's named in honor of the Johnny Bench TV show, The Baseball Bunch. It was Johnny Bench. I think Tommy Lasorda was the Swami of some sort. I don't know if that was his title. He was like a genie of sorts or a Swami, and the San Diego Chicken. That certainly was a good treasure on Sunday mornings. But anyway, we're doing it that 401k virtual bunch. We're going to do it on Thursday, August 13th. Special guest, Lyle Himbaugh from Granite Group, 4 p.m. Eastern Standard Time. Lyle's a good friend, sponsor of many events. He's been to most of the 401k conferences. I think he's one of the few people that's been to more 401k conferences than Mike Webb. I always have to give out a shout out to Mike Webb, because I know with Mike, at least somebody is listening to this podcast. So we're going to do that on the 13th. On the 14th, we're going to do the very next day, that 401k Virtual Conference 5, starting at 12 noon Eastern Standard Time. Going to go on for 2.5 hours. Advice Analytics is going to present. I'll be there. And one other provider. And it should be a lot of fun. Learn something new. It's free, more importantly. And of course, what's not free is that 401k National Virtual Conference. It's the big event that we did in Disney, but we're going to now do it virtually next January. With virtual, we don't have to worry about the weather, except, of course, power goes out, which happened to quite a few people here on Long Island. Not me, thankfully. But, January's a good time. Late January is a good time to hunker down and learn something new. January 21st, 22nd, 2 days. We're going to take all aspects of the live conference, including the celebrity guests, do it virtually, and, 8 hours a day. If we get more sponsorships, we'll do other unique things. Of course, that's all to be announced. You can sign up now, and there have been a handful of people that have signed up. It starts at $20.21, obviously, for 2021. If you want to shell out more for the autographs of the guests, you can. You want a t-shirt as well, you can get that as well. I think the top price is $140.21. That's early bird. That will change come Thanksgiving. You could go to that 401ksite.com, see the link, click on it, pay by PayPal, and you too can be a part of what is going to be a really great and virtual event. So, talking about key concepts that plan sponsors really need to be aware of, just basic concepts, the building blocks, as they would say. And number one, I'm an ERISA attorney. I don't have the ego like other attorneys, and I will say that the most important plan provider is not an ERISA attorney. The most important plan provider that a plan sponsor can hire is the third-party administrator. I'll say it until I'm blue in the face. I will say it until every plan sponsor recognizes that fact. So that means I will say that until the day I die. The problem is the plan sponsor is really not aware of what a TPA does, and the TPA does pretty much all the compliance testing, allocations, trades, plan documents, plan design work, and files the Form 5500. With so many, intricate duties and compliance testing and whatnot, and mathematics and all that stuff, so many mistakes can happen. the difference between a good TPA and a bad TPA is a good TPA makes a lot of mistakes, and when they do make mistakes, they accept responsibility. And I've seen so many bad TPAs over the years. Oh, it's not my fault. It's not my fault that the plan sponsor didn't understand what a key employee and identified everybody as a key employee to their operation, including the first person making 30 grand. There's always explanation. There's always explanation. More importantly, there's always an excuse with some bad TPAs, and they make more frequent mistakes. And the problem with TPA is, I remember the movie Casino about holes in the desert. A lot of holes in the desert. Where they bury their grudges. They dig a hole, shoot somebody, bury them. And what reminds me of the retirement plan business is when TPAs, bury their bodies, as they say, bury all their mistakes, and it's only discovered when there's a change in the TPA. Oh, look at this! You made a mistake. I mean, it happened to a client of mine where top-heavy testing was done incorrectly, and it was only identified by the new TPA 3 years later. When they changed TPAs. I didn't want to say the new TPA waited 3 years before they found the error. I'm just saying they switched TPAs, and immediately the new TPA discovered that the top-heavy test was incorrect because the named partner's wife and daughter who worked for the firm were not identified as key employees through attribution. Which, I mean, listen, they have the same name, same last name as one of the names on the door. Where I come from, we call that a clue. The TPA over there didn't understand it, and of course, there were excuses out the wazoo, which of course didn't make any sense, and the administrator working the plan had 20 years experience, and yada, yada, yada. Let's just say we got the old TPA to cough up a couple of shekels for the corrective contributions. Again, that's the problem. You only find these TPA errors most of the time when there's a change in TPA or on an audit, IRS, Department of Labor. And the problem is, of course, when you discover errors years later, it's costly to fix. Certain changes can't, at a certain point you can't make ADP refunds anymore. You're limited to making corrective contributions, so it's costly. And of course, when you're caught on audit, needless to say, government likes to sock a penalty on you. Number two, for plan sponsors, basic concept they need to understand is they have to hire a financial advisor. The Home Depots and Lowe's of the world says, with our house, we can do it ourselves. Of course, I got two left hands. I can't do anything correctly. Plunging the toilet is probably my expertise. Outside of that, I don't know anything. And of course, with the internet, back in the old days, you needed a brokerage account. I mean, when I was a kid, I didn't know what a registered investment advisor was, and if I wanted to buy stock, you had to call a brokerage house, and there were minimums, and there were huge commissions, and now I'm still amazed that pretty much everything's commission free now. I opened up was it Sophie or SoFi accounts not too long ago, and there's no commissions. I don't understand that. I could buy stock and there are no commissions, and I could buy these little portions of the stock and increases of just $1. I could buy stock. I could buy Amazon stock at $1, which of course is like 1/3500th of a share, but I still can do it. So, again, the Home Depots and the Lowe's, and on the stock market, the E-Trades, the Ameritrades, and whatever we have now in the discount brokerage firms, the idea was, well, you can you can manage your own money. You don't need a broker. You don't need an RA. You can do it yourself. The problem is, as a plan sponsor, you can't do it yourself. The moment you hire an employee, it's incumbent on you to hire a financial advisor to handle your plan. Well, listen, everybody's a genius, and everybody could pick an S&P 500 fund and then put their money all in indexes. The moment you hire an employee is the moment you have an ERISA 404C participant-directed plan. You got to give the participants enough information to make informed investment decisions. Unless you're a financial advisor or a stockbroker, you can't do it yourself. I always bring up the law firm situation, and I will always bring it up until the end of the time because I've said it repeatedly. I've never been insulted in my career the way I was insulted at that law firm when, Pat, the HR director, wanted me to help her fix the plan, and I said, Pat, these funds look really old. I mean, when did you pick out these funds? Oh, the ERISA attorney, 10 years ago picked out these funds. Pat, do you have a financial advisor on the plan? No, she doesn't. And she gives Morningstar profiles to the participants and says, good luck. There are no investment education meetings. I'm like, Pat, understand that you could be liable under ERISA 404C for breach of duty because you didn't provide enough information to plan participants. You didn't have an investment policy statement. You didn't review your funds. You didn't replace them. Yada, yada, yada. Needless to say, she took that advice, and then everything else after that, she didn't. I was the expert, but she decided that she knew what was best. She picked the advisor that I didn't recommend. I gave her 3-4 advisors to talk to. She didn't hire any of them. And then, of course, you have to hear it from someone else that they switched plan providers without discussing with you. Yeah, listen, I'm just the expert. And I was, to this day, it still boils me. It's just because I was never insulted that much in my career where somebody said, wanted my advice. I was the expert. It's not like she talked to other risk experts. I was the expert, and she knew what was best. And, that's somebody who's a control freak, even worse than I was. And, I think I told the story years later. There were problems with the plan, and somebody recommended me to one of the trustees who wasn't Pat. And he didn't remember who I was, and invited me to come down, and of course canceled the meeting when Pat found out that they were going to interview me to look at fixing the plan. Listen, I think I made it the last 10 years. I repeatedly told the story, so I understand why she might hold a grudge. So anyway, you have to hire a financial advisor. Long story short, I really went off a tangent, but plan sponsors really have to hire a financial advisor who understands retirement plans, understands the fiduciary process of the plan, knows what an IPS is, knows that they have to have fiduciary reviews and review the investments on the plan. You don't want the plan to be targeted for a class action lawsuit or even a single participant lawsuit or problems with the IRS and the Department of Labor. You need somebody who really knows what a 401k plan is and understands, the nuances, hiring good TPAs, looking more than the old days where, I found too many brokers and advisors were really interested in how they got paid, and that was it. They didn't want to service a plan. They just wanted the quarterly fee and never bother showing up to the client and never reviewing funds and all that kind of stuff. You need, not just an advisor, you need an advisor who really also serves as a plan consultant and really is like the ombudsman. When something breaks, they really rely on the financial advisor to talk to the TPA or talk to other plan providers. There's so many working components to a 401k plan. You need somebody who understands. Listen, not someone who's a qualified pension analyst or qualified pension consultant or a risk attorney. You need an advisor who just understands, the issues that may come up, and then rely on the providers that they work with to get the answers for the plan sponsor. You need somebody who really just knows what they're doing and has experience, and really understanding of what really, works in the plan and what doesn't. And, that's the person that you really need to rely on. You need to get fiduciary liability insurance. Number 3. Again, plan participants, employees, you can get sued. We all know that fiduciary liability insurance is not an ERISA bond. An ERISA bond is required. Fiduciary liability insurance is not. ERISA bonds protect the assets of the plan. Fiduciary liability insurance protects fiduciaries from litigation costs, from personal liability that they could any breach could result in because they are plan fiduciaries, and plan fiduciaries may involve personal liability. So you need a fiduciary liability insurance when you get sued. If you get sued, um, insurance company hires the attorney for you, or pays the legal fees subject in settlement, subject to obviously what the deductible is. Many years ago, when I worked at a union law firm, they had a big union that had a retirement plan that was a class action lawsuit. It's $1 million in legal fees. They won the case on summary judgment. They still had $1 million legal tab. Thanks to fiduciary liability insurance, they only had to kick in $100,000. That's good. That's great. So it's protection. They're not expensive. They're not as expensive back in the day in the early 1990s or late 80s of insuring a new car in Brooklyn, New York. You can get fiduciary liability insurance for a lot more. Here is the scary fact. Speaking about car insurance, we lived in Brooklyn. When I turned 18, parents got an Acura Legend, 1990 Acura Legend. I want to say the insurance was $3,000 for Brooklyn. I want to say now I have some older cars. I have a 2012 Prius V and a 2012 Mazda 3. I pay less in insurance on Long Island for the two cars. I paid $2,400 with Allstate. I paid less in 2020 as opposed to $1990. I would think in $1990, $3,019 is probably about $4,000 today. I guess, I don't know. But anyway, that's another aside. Again, it's less, fiduciary liability insurance is a lot less than car insurance in Brooklyn, New York. That's why in those days you'd see a lot of Florida license plates in North Carolina. And even today on Long Island I see it. I say, oh yeah, you're not from Missouri. Come on. If you're from Missouri, why are you here? I mean, Florida plates, North Carolina, South Carolina plates, a lot of it's just insurance fraud. But anyway, next thing a plan sponsor really has to do, but doesn't really do it, is reviewing the plan. You can't have a set it and forget mentality. You can't just place the plan. You can't be like Pat, the HR director of my old law firm, and just say, you know what, I set up a plan and that's it, and I'm not going to pay attention to it until I find a really dumb associate risk attorney who I'll just glom some ideas off of and then not get involved in the process. Again, I'm bitter about that. So, reviewing the plan is, like I said, looking under the hood, seeing what works, what doesn't. Does a plan still fit the plan sponsor's needs? Plan providers still work? Is it still a good fit all around? Is the plan design a good fit for what could be a changing demographic? Every 1 to 2 years, it's a good idea to really check what works and what doesn't. Years ago, I had a medical practice client. Defined benefit plan really worked when they had 5 employees. It no longer worked when they had 12. So that's why we implemented a 401k plan. And last but not least, it's important that the plan sponsor understands the need to review fees. Fee disclosure to me has been one of the greatest things that ever happened to the retirement plan business. Why? With a lack of transparency, plan sponsors didn't understand how much they were paying in fees, which was a problem when they had the fiduciary duty to only pay reasonable plan expenses. And how do you know if it's reasonable if you don't know what it is? Right. And of course, as I say that, my son had me play the Best of Billy Joel, volumes 1, 2, and 3, and the song just popped in my head. But it's important that fees get reviewed. The reason is you don't know how much you're being charged and whether it's reasonable unless you see what other people charge, either by talking to other plan providers or using a benchmarking survey or plan averages book, whatever it is. do some research, identify whether the costs are reasonable or not. The fee disclosures you get should be put in back in, should be put in the garbage, the waste basket. It should be put in the back of the drawer. It shouldn't be used to wrap fish. It's there. It serves a purpose and a function. And if you don't use it, you're going to be in problem. You're going to have trouble. Especially, Department of Labor audit. Again, I went through a Department of Labor audit not too long ago. Auditor says how these, providers get picked. And, how did you check reasonableness of fees? Well, you can't say duh. You actually have to show what you did. So it's important to obviously refute fees. So again, hopefully you enjoyed this 100th episode of that 401k podcast. To 100 more. Check out the Zoom meeting, that 401k virtual bunch on the 13th, that 401k virtual conference number 5, and that 401k national virtual conference in January. Sign up, $20.21, and of course higher fees if you want more stuff in your little grab bag. So hope you guys tune in next week with another edition of that 401k podcast.